A new Supreme Court ruling out just today makes it illegal to fire gay and transgendered employees on the basis of their sexual orientation or their gender identity. Now, I actually think this ruling is a good thing. It clarifies the 1964 Civil Rights Act. Some people are arguing that it expands beyond the original bounds of the act, and to be really honest, I kind of wondered that myself when I first heard about the ruling, but now that I've read some of the rationalization for it, I'm completely on board. Listen, there is absolutely no reason for employees to be fired based on these grounds anyway. However, that doesn't mean that it won't continue to be a problem, and we're going to talk about why that is, because employers very rarely give the actual reason that someone was fired when they're doing terminations. It's just the way it is. I'm going to provide data to prove it. But first, let's understand what this ruling says. Civil rights law protects gay and transgendered workers. Supreme Court rules. This is from the New York Times. The court said the language in the Civil Rights Act of 1964, which prohibits sex discrimination, applies to discrimination based on sexual orientation and gender identity. The Supreme Court ruled Monday that a landmark civil rights law protects gay and transgendered workers from workplace discrimination, handing the movement for LGBT equality a stunning victory. And here's actually what I think is most stunning and actually pleasing to me. Neil Gorsuch wrote the majority opinion. The vote was 6-3, with Justice Neil Gorsuch writing the majority of opinion. I always liked Neil Gorsuch for some reason. Even when I had my epic case of Trump derangement syndrome, Neil Gorsuch always struck me as a very fair and balanced jurist. I never had any problem at all with him being appointed to the court. He was joined by Chief Justice John Roberts, Justice Ruth Bader Ginsburg, Stephen Breyer, Sonia Sotomayor, and Elena Kagan. The case concerned Title VII of the Civil Rights Act of 1964, which bars employment discrimination based on race, religion, national origin, and sex. The question for the justices was whether the last prohibition, discrimination because of sex, applies to many millions of gay and transgendered workers. The decision covering two cases was the court's first LGBT rights since the retirement of Anthony Kennedy, blah, blah, blah. These decisions were grounded in constitutional law. The new cases, by contrast, concerned statutory interpretation. And I think that's a really key point here. What you're going to see in the argument is it's not so much about whether or not, listen, here's what's going to happen. There are going to be accusations from the left that the Trump administration was trying to promote the firing of gay and trans employees, and they wanted to be able to fire them on the basis of their gender and sexual orientation. And that's not what we're talking about here. This was an interpretation of a statute. That's what we're talking about. You've got one side that's basically arguing that discrimination based on sex should cover gay and lesbian employees and also trans employees. That's what you've got on one side, that the sex provision of the 1964 Act covers sexual orientation and gender identity. On the other side, you have people saying, well, no, it doesn't cover discrimination based on those things, but wouldn't it be nice if there was an addendum to the law or a new law passed that said these things were included? That's what we're talking about here. We're not talking about one side saying that employers should be able to fire on these grounds. What they wanted was to have a new law passed in addition to the one that already was passed. That's what we're talking about here, and I think that's a really important distinction to make. Lawyers for employers in the Trump administration argued that the common understanding of sex discrimination in 1964 was bias against women or men and did not encompass discrimination based on sexual orientation and gender identity. If Congress wanted to protect gay and transgendered workers, they said, it could pass a new law. So it's not saying those workers shouldn't be protected. It's saying that the current law does not cover it. That's what the Supreme Court disagreed with. It's saying effectively the current law that's already on the books covers these elements as well. And again, this is something that I agree with their interpretation on it. Lawyers for the workers responded that discrimination against employees based on sexual orientation or transgender status must, as a matter of logic take account of sex. So what they're saying is that the 1964 law protects discrimination based on sex. Well, if you're fired because you're gay, well, yeah, your sex is actually an inherent part of that decision, because I couldn't be fired for loving a man, but a dude could be fired for loving a man. Right? So inherently the person's sex is accounted for in that decision. And the same thing with if you're transgendered, your sex is inherently a part of that identity and part of the decision that comes into play when they're making the decision to fire you if you happen to be trans. So I absolutely, again, I agree with this call. I think it's the right one. The court considered two sets of cases. The first concerned a pair of lawsuits from gay men who said they were fired because of their sexual orientation. The second was about a suit from a transgendered woman who said her employer fired her when she announced that she would embrace her gender identity at work. The first case was filed by Gerald Bostock, a gay man who was fired from a government program that helped neglected and abused children in Clayton County, Georgia, just south of Atlanta, after he joined a gay softball league. The second was brought by skydiving instructor Donald Zarda, who said that he was fired because he was gay. His dismissal followed a complaint from a female customer who expressed concerns about being strapped to Mr. Zarda during a tandem dive. Mr. Zarda, hoping to reassure the customer, told her that he was 100% gay. Mr. Zarda died in a skydiving accident. That's too bad. But his state pursued the case. I mean, think about the determination of the people behind that estate. I mean, that to me says something, honestly. Most federal appeals courts have interpreted Title VII to exclude sexual orientation discrimination, but two of them in New York and Chicago have ruled that discrimination against gay men and lesbians is a form of sex discrimination. In 2018, a divided 13-judge panel of the United States Court of Appeals for the Second Circuit in New York allowed Mr. Zarda's lawsuit to proceed. Writing for the majority, Chief Judge Robert A. Katzman concluded sexual orientation discrimination is motivated, at least in part, by sex and is thus a subset of sex discrimination. And then we have the opposing side right here. And again, this is the distinction that's really important to understand. In the dissent, Judge Gerald Lynch wrote that the words of Title VII do not support the majority's interpretation. Speaking solely as a citizen, he wrote, I would be delighted to awake one morning and learn that Congress had just passed legislation adding sexual orientation to the list of grounds of employment discrimination prohibited under Title VII of the Civil Rights Act of 1964. I am confident that one day, and I hope that day comes soon, I will have that pleasure. So what this person who dissented to this decision when it was in the lower circuit or the lower courts, what he said was, man, it would be great if Congress passed this law, but the courts should not be interpreting this. So this is a fundamental, I think, difference between how the judges perceive the role of the courts in interpreting these laws and statutes. And honestly, frankly, I'm kind of surprised that Neil Gorsuch came down on the side of saying that it does apply in these cases, because that just doesn't really seem to be his jam. He's like a very strict constitutionalist, but I'm pleased with it. I think it makes a ton of sense. Let's see. I'm just going to scroll down here a little bit more. Okay, let's take a look at the transgender case. The case on transgendered rights is it's basically someone who was working at a funeral home who sued the funeral home. It concerns Amy Stevens, who was fired from a Michigan funeral home after she announced in 2013 that she was a transgendered woman and would start working in women's clothing. Miss Stevens died on May 12th. That's too bad. It's so sad to me sometimes when I hear about cases like this where people are fighting for years and years and years and then they don't make it to see the decision that turns out in their favor. But I mean, their efforts have impacted a lot of lives, and I suppose that I'm sure that's something they're looking down and being very happy about. This was a letter that she wrote to her colleagues, basically coming out as transgendered. What I must tell you is very difficult for me and is taking all the courage I can muster, she wrote to her colleagues in 2013. I have felt imprisoned in a body that does not match my mind, and this has caused me great despair and loneliness. Ms. Stevens had worked for the funeral home for 6 years. Her colleagues testified that she was able and compassionate. 2 weeks after receiving the letter, the home's owner, Thomas Roast, fired Miss Stevens, asking for a specific reason that you terminated Stevens. Mr. Roast said, well, because he was no longer going to represent himself as a man. He wanted to dress as a woman. Now, this is a very clear-cut case of someone being discriminated against because they are transgendered. But what I want to make sure that I really articulate to you in this video is that this doesn't usually happen. This does not usually happen when organizations are firing employees. They very rarely, I mean, this probably happened because it's a funeral home. It's like this little small family business. There's no HR department to prevent them from getting into trouble and saying things they shouldn't, right? There was no one there to do that. But in most organizations, that's not going to happen. And I know that because I've actually studied the employee experience of being fired. This is a piece I wrote for Forbes sometime, I think, at the end of 2018, where I essentially studied over 1,000 people who had been fired from their jobs to understand the employee experience of being fired. And there's just a couple things I want to point out for you in this data. So of those who participated in the study, 75% of them said their managers never met with them to discuss their concerns before firing them. So there was given no opportunity to discuss concerns or given chances to improve. 90% of them weren't put on any sort of performance improvement plan. So really, when we see statistics like that, you have managers, you have organizations that are not interested in really improvement or getting employees back on track or any sort of conversation about that thing. They're interested in getting the employee out. That's what we're talking about here. But that's actually not the most compelling evidence. I'm going to scroll down a little bit more. Okay, so how did they perceive their firing? In most situations, employees have an at-will agreement with their organization, which means they can be fired at any time, for any reason, or for no reason at all. So let me just say that again. The vast majority of employees in the United States can be fired at any time, for any reason, or for no reason at all. Your employers are not obligated to give you a reason if they fire you. They can just say, nope, it's done, it's over with, and leave you, send you on your way without having that type of closure. It happens all the time. So when we're talking about rulings like this, I bring this up to say that your employer's not obligated to say, I'm firing you because you're trans, I'm firing you because you're gay. Most of them are not going to do that. And in those cases, it becomes incumbent upon the plaintiff to prove that that's what happened. And you can see in here what I found is that most were actually given a reason for termination. 80% of people in my study were actually given a reason, so only 20% were given no reason at all. However, 58% of them did not believe that the reason that they were given was the actual reason. And there could be any number of things. So what employers tend to do when they want to get you out is they will find a reason. They will figure something out. They will go through every single email because, yes, they have access to your email. They will read every single email you've sent. They will take a look at every single note. They will look at every single HR complaint that's ever been made about you. And trust me, when we get into the era of microaggressions in the workplace, that could be an awful lot when you haven't actually done anything wrong. They will find a reason to get you out. They will find a reason to give you. So the moral of the story here is that if you get even an inkling that your sexual orientation, your gender identity, or frankly anything else is causing your employer consternation or strife, and just make sure you document everything, is what I'm really trying to say. Make sure you document everything, because unless they tell you flat out, just like that funeral home did, to say, well, the reason I'm firing you is because I hired a man and you're no longer are representing yourself as a man. Like, if they're not giving you that reason, it becomes incumbent upon you to prove that's the reason. And that is actually a really tough step to take. So, that's just the way it is. That's the world we live in. Again, this is why I think that this is a good step, but I don't actually think this is as impactful as people might be thinking it would be. The U.S. Court of Appeals for the Sixth Circuit in Cincinnati ruled for Ms. Stevens discrimination against transgender people, the court said, was barred by Title VII. It is analytically impossible to fire an employee based on that employee's status as a transgendered person without being motivated, at least in part, by the employee's sex. So again, I think that's a really good thing. And actually what you're going to find is that the majority of Americans actually agree with this in principle. So here is where people stand, just the general public, and then broken down by political party, for whether or not it should be illegal to fire people who are gay and people who are transgendered. And this is again according to the New York Times. Take it for what you will. Where the public stands, it should be illegal to fire people based on sexual orientation, or it should be legal for employers to fire people based on sexual orientation. So we've got that, listen, 83% of Americans saying it should be illegal to fire people on the basis of their sexual orientation, 79% saying it should be illegal to fire people for being transgendered. And if you look at the breakdown by party, I mean, you might expect Republicans to be in the toilet on this one, but they're not. 3/4 of Republicans think it should be illegal to fire someone on the grounds of sexual orientation, and 69% say it should be illegal for transgendered. And of course, that number tends to be higher for independents and even higher for Democrats. So you can see that public opinion is on their side here. I think this is symbolic. Again, I think this is a really good symbolic victory. I don't think this is actually going to have as much real world implication as people think it will, because A, most employers are not firing people for these reasons. They just aren't. I mean, at least none that I've ever worked with. And in fact, they go out of their ways to make sure there's a welcoming environment for all employees, whether they're gay, whether they're trans, no matter their color, all this stuff. I mean, honestly, I'm actually much more concerned at this point about people being fired for being Trump supporters than I am about people being fired for being gay or transgender. That's actually a much bigger problem. We're seeing people fired left and right, hand over fist, for being Trump supporters, but we are not really seeing a rash of cases for people being fired because of their sexual orientation or gender identity. That said, again, I'm going to beat the dead horse because I don't want anyone to be able to accuse me otherwise. I think this is a good ruling. I think that it is a good clarification of the law. I'm happy to see that Neil Gorsuch wrote the opinion on it. I think this is a good step. And what I really hope is that, you know, listen, I know that I'm daring to dream with this, but can we just celebrate the fact that no one really disagrees with this in the American people? I mean, there's a little bit, but really, everyone is on the same page in regards to this. And I really hope that the media doesn't have a field day with this and basically says, well, the Trump administration wanted to discriminate against these people. Of course they will. Of course, that's exactly what's going to happen. But that is not what the articles say. That is not what the actual arguments were. Again, I'm beating a dead horse here. What the article said was that one side was basically like, the 1964 Act covers sex, which inherently covers these other categories. What the Trump administration, the Justice Department was saying, no, the 1964 Act does not cover these categories, but if you want to cover these categories, pass a new law. So even if this case had been lost, there would have been nothing from preventing Congress, other than an absolute inability to act like adults and work with each other, from passing a new law in these areas. Again, this is a victory for 83 and 79% of people, respectively. It's a good decision. It's a good thing. I don't think it's going to have that much impact in the real world, but it makes people feel good. And, you know, there is some importance to that. It is important to have these symbolic victories to say, these are the values that we hold as a society. It should not be about how you identify or how you present. It should be about the value of your contribution. And that's exactly what should happen in the workplace. If you're going to be let go, it should be based on your contribution, not based on who you love or what clothes you wear or how you present or your political affiliation or your religious beliefs or any of these things. It should be related to your ability to contribute to your organization productively and meet the core competencies of your job. Everything else is just noise.